CPIO, in turn CPIO will involve. That's not the expectation of the Act. The Act says that whatever record is there in your office, if on that date the record shows that there is no encroachment and that is reported, that would be given. That can't really put the CPIO into a false position.
Actually, there is only one provision, one thing which can be done by the Information Commission. Something similar has happened in Tamil Nadu that is relating to vigilance case. Okay. Now, what can be done? The only possibility, according to me, is that if we find that there is an enforcement, but whereas the record shows that there is no enforcement, the appropriate authorities, where maybe the development authorities or the appropriate government, they will have to inform that this is the case which has been reported, and it is for them to do take follow-up action. The Commission does not have executive powers. They cannot direct an investigation or an inspection if records do not show that.
Excuse me, I think PIO furnish information and then appellants or complainants say it is wrong information, and suppose a PIO doesn't have all records because he's not dealing entire dealing. It might have been dealt by some other public authority or officers. In that case, that other officers, the third party, he must have given wrong information. In such cases, I have faced. Then I make that other information, other officers is a dim PIO. In that case, I summon him and I verify whether that information is wrong and right. And if there is certain file is there, so you can inspect it and then authenticate it, whether this information is wrong or right. So in that case, if necessary, inquiry we also, I think, instituted. So such cases are there. And another case that information you were saying about yes or no, you cannot ask. But what I feel is that in some information, yes implies informations, documents. For example, somebody asked like whether you have got government allotment of rice. And that case, if no is okay, no. But if yes, so certainly document is that document could be furnished. Only you cannot simply reject that whether that you have asked yes or no. So it is no or yes. So other information I cannot furnish. I think that should not limit it to that. Thank you.
First cases and questions are not outside the purview of Section 2F. Number two, even CAC in Virchandra Shah versus Central Excise, they have also ruled that queries which were in the nature of soliciting explanation reasons from the authorities were outside the purview of the Section 2F of the Act.
Yeah, Venkatesh. Sorry. Please respond, sir. Okay. You want to add something?
Yeah.
To this? I think there is a serious.
In Karnataka Information Commission directed the BBMP Corporation to rectify and file a complaint. They approached the Honorable High Court. High Court said that it's not an inquiry commission or a Judicial Commission. It is only the Information Commission. Only you can direct the higher authority to conduct the inquiry of the officer which is paid in his duty, but you can't give the direction. It is the order of the Karnataka High Court that limited the power of the Commission. Only available information can be furnished, but no power to give the direction to any authority.
Instructions, and later on, or let's say if the applicant himself has records which show that there is unauthorized construction, that is a matter of serious concern that the administration is flawed. They are not giving accurate information to people, number one, and number two, they are not maintaining accurate information. In many right to information bills that are being debated around the world, the right to access information actually includes the right to get accurate information. And it is a responsibility of the public authority to ensure that accurate information is given. Whether penalty should be put on a PIO or somebody else is not an issue. Is not something that one can argue on too much, because if the information officer himself is not responsible for generating that record, then why should he be penalized? That is the first question to ask. The other person who generated the faulty record is the one who should bear the burden of penalty. Now, whether this should be done under the RTA Act or it should be done outside of the RTA Act in the normal course of administrative law is something that is going to be dependent on each case. But what is worrisome are two things. That practices that have been laid down for guiding the bureaucracy to undertake routine government work are being ignored routinely. This is the biggest problem. An excuse saying that Reasons are not available on file. We only have a decision, and therefore you can take the decision and go and do whatever you want with it. I think is unacceptable in the age of administrative law, where they say that even administrative discretion must be used based on guidelines. So reasons must be given. Every manual of office procedure says that when you take a decision, you have to give your reasoning. Opinion given by various people in the chain of decision making must be recorded on the file notings page. If this is not done, and in an age of RTI, if post-its are being used for this purpose and then taken away, there is a serious problem with the way the administration is functioning. The second point about cabinet notes I want to mention is this. What is the great difficulty in sharing with people proactively the reasons for a cabinet decision when part of the cabinet note includes a press release? Press release is part of the cabinet note. So if a decision is taken, the press release is going to be given to the Press Information Bureau to share with people. So should that not be drafted in such a manner that the reasons are given there? Thank you.
Provided. So if there is any lapse on the part of the person who is having that information but is not providing the information to PIO, then that person is made a deemed PIO and is liable for further action. So that is what we are doing there. You want to say something?
My question is not answered because unless it is otherwise proved. Of course,
No, sir, I respectfully disagree with High Court judgments. Provided you give your reasons. I don't think any High Court judgments are binding on us.
even the CIC has also proved the same thing.
Yeah, the CIC will certain the Mishra Saab here, and maybe we can take it further. You see, if one interprets the law such that even if that record is garbage, if it is given to you under the RTI, then the RTI Act cannot take any action further on this matter. Then you are promoting a culture where purposely all garbage records will be maintained to be given out under RTI. A strict reading of the Act, and there can be two views on this, and we need to evolve this. A strict reading of the Act would suggest that if somebody has knowingly given wrong information, and this wrong information might have been knowingly given not by the PIO but by the person whom the PIO sought assistance from, then that person is liable. Now the problem comes if that person has not knowingly given it, meaning that report was...
No, sorry, Mr. Gupta. That is paper record. So anybody from the office, whether the CPIO or the person whose assistance he is seeking, is supposed to give the information as available on record. And supposing somebody goes and says that how many corrupt officers are there in your office, what will he say? He would say, if this is not recorded anywhere, he would say that there is no record showing that there is any corrupt officer in this office. And supposing the citizen knows that half of the officers of that office are corrupt. So who will sit in adjudication whether the information provided is right or wrong?
You're quite right. Let me give you an unauthorized construction what will be. If the RTI query says, I understand that a report had been done by Mr. X, please give me a copy of that. No problem. Whatever is garbage in that report doesn't. Suppose the RTI application doesn't say that. Suppose the RTI application says, please let me know if there are unauthorized constructions in that locality. Now, suppose the PIO himself or an officer he seeks assistance gets that file out and gives this report knowingly. Now, what does knowingly mean? There might be a file noting there which says that this report was put up to the chairman of the MCD, but the chairman of the MCD says this is all wrong. There is contrary evidence to this, so this report is obviously full of falsehood. Suppose there was a file noting on that. This means it reads it, yet provides that report to this applicant who has not asked for the report, who has asked for the status of illegal construction. I would say that he is liable under the right to.
And anyhow, that whether a construction is authorized or unauthorized is a quasi-judicial process by which it will be decided by a competent authority. Nobody can simply say that this is unauthorized just because I feel that this is unauthorized. It may be unauthorized, but my word is not the last word on the unauthorized nature of that construction until a competent authority decides. So therefore it's an extremely problematic area if we persist on this and think that merely because the people think or even the officer thinks that it is unauthorized, he should give his personal opinion contrary to whatever there is in file. It would be entering into a very extremely problematic area in the RTI. So let us restrict ourselves to whatever there. I agree that if there are records and I disclose only something which I think favorable to me and suppress some other records, I am guilty.
And suppose after that, as has happened in one case in Delhi, the inspection report, which is written by the officials, does not match maybe photographic reality of that inspection done by the applicant, then is there liability on that?
No, even then, the truthfulness of there is a competent authority, and Mr. Gonsalves, being a senior lawyer, would know that all such allegations will have to be proven by somebody with adequate evidence. It would be premature for the CIC to conclude, or the Information Commission to conclude, that the information is wrong, and therefore
I think other organs of governance are so poor that the expectation is that whatever is missing elsewhere can be done by RTI. I think RTI also has some limitation.
I think such kind of things should be taken to the appropriate, forum. I mean, who can act it. For example, suppose there are questions like this: why ethylene transfer? The transfer is administrative, course. I cannot interfere. Only I can, ask for the documents. How you have been transferred? I can punish the document as a commissioner. But why you have transferred? I cannot question the authority, because it is administrative matter. And such cases like this, suppose it is unauthorized. So this verification should be done by the proper authority, not by the, I think, Information Commission. And that way, I think expectation will be too much. It will be difficult for the commissioners, and which we have also not vested powers, and we have got very limited powers.
This 1984 says, by making necessary changes to its practices in relation to the maintenance, management and destruction of records. So in the maintenance of records, the public authority can be directed by the commission in this respect. So I am responding to what Mr. Brigadier said. Necessary changes in the administrative, like the cabinet paper, when the press note is given, the commission can direct that the press note should contain such and such details. So that can also be thought about.
Of the Information Commission vis-a-vis the competent authority. Now, in this very specific case, namely the so-called unauthorized construction, the Information Commission has no competence to decide whether it is right or wrong, unauthorized or authorized. The only thing the Information Commission can decide is the information produced by the PIO, whether it was available on record, truthfulness, whether it was fabricated or deliberately suppressed or falsified. The entire power is limited only within that band. It cannot step outside and then arrogate the powers of the competent authority, however high or low it may be. So here, it is the appropriate development authority, maybe MCD or KCMDA only can decide, and not the Information Commission. You only refer, maybe under appropriate positions, refer to the government in appropriate body, say that this is what has happened. It is up to you to take a decision. We cannot sit in judgment over the decision of a competent authority.
Wherever such very stark differences have come to our notice, invariably I have always ordered a comprehensive inquiry at the highest level. And that inquiry report reveals quite a lot of things. Some tasks which were not done were also taken up. And then finally, you get a new set of information actually as part of that inquiry report. But having done so, my problem is now, whenever I usually release some additional information through the process of inquiry, then the appellant and complainant comes back. He said, now the earlier information and this information, there is a difference, so the earlier information giver must be punished.